And then so if you just bear in mind the recording is not going to be shared to the public, but some of my client that cannot make it to this event, I may send them a copy. So any question that you may want to ask Jennifer at the end, just bear in mind it's being recorded. Okay, for people getting in. All right. And so first of all, I want everyone to welcome Jennifer. Jennifer Fu is an attorney here in Diamond Bar area, and she specializes living trust and probate. Jennifer, could you give everyone a Reader's Digest of about yourself?
Sure. Let me go ahead and share my screen now. I think I have a slide about myself.
That
Um,
works.
okay. So good morning, everybody. Happy Saturday. So today we're gonna go into some estate planning and trust-based strategies. Um, I go to the next page. Hold on. Give me 1 second. Okay. So this is my law firm. We're called Amity Law Group. We're women-owned, Asian-owned. We focus on estate planning and probate. We also do some employment law. And then we're based in SoCal. We have Diamond Bar, Tustin, and Rosemead. We're actually going to move to Covina, so very soon in May. So a little bit about myself. I am the managing partner of Amity Law Group. I graduated from UC Berkeley and Golden Gate University School of Law. I have about 20 years of experience now, and then I do mainly probate, estate planning, and some employment law defense work. I can speak Mandarin, Cantonese, Taiwanese, and English. Okay, so let's get right into it. Estate planning, today we're going to cover what the objectives of estate planning is and what it really means. And then talk about, what happens when somebody passes. I think that's always not too clear. A lot of people come to us and say, oh, I thought it was automatic, or it just happens, it should happen a certain way because we're married, or these are my parents, or these are my children. And so we can talk about that a little bit. And then what happens through probate? So why do we try to encourage people to avoid probate? What are the consequences? And then I think it's also important to understand the differences with estate tax and gift tax, especially if you are a non-US citizen, and what those differences look like in numbers. And then we will close with how this trust can help protect your assets and kind of the benefits of having a trust. Okay, so we want to do an estate plan. Number one is to avoid probate. Okay, so probate is very costly. We'll do some examples and you'll see kind of the savings that you will have if you avoid probate. We also want to minimize any estate taxes or lower any expenses that we have to pay out, right? So that's also a very important objective. And then you want to decide who your beneficiaries are. You don't want somebody else to make that decision. You want the control. You want to know that, if it goes to your children, it's given the right way, maybe by a schedule or a certain amount. And then maybe you want to donate some, to some charity. So you have that control, you have that right. So if you do an estate plan, you can make those decisions and plan it out according to what you want to happen. And then you also still want to maintain some control and flexibility, right? So once you start an estate plan, you basically, in case you want to sell the house, you want to do some changes to what you had planned, you can still do so within your control. And then also you want to make sure your family's provided. If you have minor children, you want to make sure that they're taken care of in case something happens to you. So that's very important part of estate planning. And then also in case somebody gets disabled or you have somebody in your household that has special needs, You want to make sure, you know, they continue to get support from your assets and you know, your family. And then if you run a business or you own a business, you want to make sure if something happens to you, you get sick, that your business still is able to continue to run. Either your kids or your family members inherit it, or some plan is made with your business partners or your other shareholders. So these are kind of the plan objectives that we want to prepare for in case something does happen, where, you know, we get into an accident, we get sick, you just never know, right? Okay, so what happens when you pass away? If you pass without an estate plan, no will, no living trust, then what we call that is intestate. So intestacy laws then kick in. So you have to go through probate, and then when you petition to probate, currently in LA County, Orange County, pretty much within our areas, it takes about 1 to 2 years. And the area that you petition for probate generally is where you reside, where you know, where your primary residence is. So if your house is located in LA County and that's where you lived before you pass, then we would petition for LA County probate court. And right now it's about 1 to 2 years. And then if there's a dispute, if somebody challenges it or, you know, says, hey, he or she promised me that I was supposed to get the house and this is my evidence, then it's a disputed or litigated probate case, and that'll take even longer. And then finally, the court will make the decision as to where your assets go. And then if you have minors, if something happens to you and your children, your heirs are still minors under 18, then you have to go through another process called guardianship, which again increases the time the probate case needs to be handled and going on. So it gets quite complicated and costly, time and a lot of delay. And then if you pass away, but you had a will, and then you owned over $184,500 in assets. Even with the will, your will still need to go through probate, okay? Because your assets exceed what the law requires. So pretty much if you own a home in Southern California, anywhere, you're gonna go over that amount. And keep in mind, it's not how much equity is in your house. Even if you have a mortgage, let's say, you know, your house somehow, I don't know, $500,000 house, and you have a mortgage that's like 400,000. So you owe the bank 400,000. So technically your equity is only 100,000, and you think, hey, I'm under this 184. No, they want to look at the fair market value of the house or your assets when you pass, regardless of how much you owe the bank. So any property that you own pretty much will take you over this $184,500. So a lot of times our clients will come and say, oh, I just wanted to do a will, because I just want to, you know, write a will and plan out for my assets and make sure, you know, I name beneficiaries. But that doesn't take away the need for the probate process. So the will is not enough if you pretty much own a home in California. Okay, so if you pass away with a living trust and then all your assets are funded into the trust, all your beneficiaries have to do is obtain your death certificate, have a copy of your trust, and then they can do the transfer documents, get it recorded. No need for any court to get involved. The judge does not have to get involved, none of that. So you basically don't have to go 1 to 2 years of this court proceeding to inherit your assets. It's very clear, very straightforward, simple.
So Jennifer, so without a probate, if if the someone has to go through a probate, essentially their entire assets, it's tied up with the court. The heir cannot touch anything, cannot, with the money, with the assets. They have to wait until the probate's over, right?
Right, right. When we do a petition for probate, the first step is for the court to authorize somebody to act as a representative of that estate. Generally, that alone takes about 4 months. Once you are appointed, you have the authority to sell these assets, okay? Because you're now the representative, but the money, the proceeds, you cannot take home. You have to go through, put it into a state bank account that needs to be reported back to the probate court until the judge signs off on the order to distribute the money. So all of that is tied up with the estate through probate. And then with probate, you have to do a publication basically saying, hey, this person passed away. Does he owe any money to anybody? And there's a 4-month window for creditors to come and make a creditor's claim. And that includes like if they had, medical bills that they didn't pay off, credit cards, any, other potential debt that they owe. So then it becomes, you have to accept the debt, you have to negotiate the debt on behalf of the estate. And so this whole process, it takes time and money, and it gets complicated. So we try very hard to let people know, plan ahead. And we all have to go through this process. All of us, it's the circle of life, right? We have to go through these things. And I think a lot of times culturally, I've had situations where a husband wants to do an estate plan, but the wife doesn't, because the wife doesn't want to talk about this topic. It scares her. She thinks it's a bad omen, to talk about it, because once you open this door, then it's going to happen right away. So it gets, a lot of times it's a cultural thing, tradition. So we're trying to educate people to say, hey, it's fine to openly talk about it. There's even my parents back then, they purchased plots already. They planned out their funeral and that ceremony. They paid everything off just because, they don't want us to have to deal with it suddenly. And then have to, be doing that while we grieve our loss, right? So a lot of this is pre-planning, and it makes sense because you'd rather spend a little bit now than wait and have your children or your family have to spend a lot later and make it a lot more difficult for them. So if you look at probate costs, just this chart basically shows what cost you're facing. So I would say, even taking like a $700,000 asset, you're looking at just cost alone is $34,000 in fees that your heirs will have to cough out to pay. And then I think, for the most part, at least I know in Diamond Bar, I don't think there's any single family home that's less than $1 million now. So you're looking at like 46,000 just in fees that you save your family from having to cough out. And then plus an additional, about 2,000 on average for filing fees. And I think that's even gone up. So every year the court filing fees goes up too. So you want to make sure you can avoid all this just by doing a simple estate plan. Okay, so this is an example. If you only have $500,000 total in your estate, you're looking at $26,000 in court fees. That's the probate fee. $100, we have to publish the passing, right? So the creditors can come and try to make a claim. And then you have an appraisal. So the court will appoint what they call a court-appointed referee who does the appraisal, the official appraisal, and that gets reported back to the court to know how much your estate was worth when you passed away. And then if you have, sometimes we need a court-appointed trustee just to oversee everything that the court decides. So it's $13,000 there. So you're looking at just 500,000 total estate, you're looking at 39,600. And that's right now. And I'm assuming, you know, like with everything gets more pricey as the years go by. So, but this is an example of, you know, the potential cost that you'll have to spend, or your family has to spend if you don't do anything. Okay, so I mean, I think in our area, we just, you know, have a lot of clients that have maybe a spouse that is a citizen or green card holder, and then the other spouse is not. Many times, you know, especially the new immigrants, maybe mom brings the kids over to the US and then dad stays behind in Asia to continue to work and not necessarily get status in the US. So this is important to note because US can tax your estate if you own any tangible property in the US, even if you're not a US citizen or green card holder. So when they come to the US and they buy a home, then let's say it's under the wife's name and the wife is a US citizen, then that means she has the lifetime gift and estate tax exemptions that are on the under this US citizen and permanent resident chart. Right now, we each have 13.61 million. If you're a US citizen, that is exempt from any taxes when you pass away. So if that means if your total, your home, your business, your bank accounts, your stocks, like all of that added together does not go above 13.61 million, then there's no tax. Okay. But if you are a foreign national, you don't have a green card, you're not a US citizen, you only have $60,000 that is exempt from estate tax if you own any tangible property. So tangible property is like if you own like a house, right? So it's, you can see it, you can touch it, it's a tangible item. If you have cash in the bank account, like any checking savings account, CDs, those are all tangible items. So if you pass away and you're not a US citizen and you're not a green card holder, then you only have 60,000 that is not taxable. Anything above that is taxed. It's important to note because you know you want to plan ahead, right? So if you purchase the home and you're a foreigner, but by the time you pass, you've gotten your green card, then you're safe because you have the higher estate tax exemption. So it's based on the status of when you pass away, not based on the status of when you purchase the property. Okay, so that's why, you know, when I talk with my clients, especially couples who are new immigrants, I ask them, you know, is your plan to eventually get a green card? Because if it's not, then you need to maybe plan to do something about it. Either you eventually sell the property, you eventually try to get the status before you pass, or, you know, maybe have everything under just one spouse's name or your children's name if they're adults, if they also are US citizens or permanent residents. So it's just a number to keep in mind. And then this number is going to change. So in 2025, the current estate tax exemption amount is going to sunset.
Sorry.
Oh, it's okay. Yeah, so in 2025, this current estate tax exemption of 13.61 million is supposed to sunset, meaning it's supposed to revert back to the original or previous number of 500 million. Or 5 million, I'm sorry. So then, and this is one of those things where it's going to constantly be updated or changed. So we do have clients, if they are higher net worth, where they want to pre-plan some gifting, then we can set up like a separate type of trust for them to make gifts into that trust so that they can claim the 13 million now. Because once it's gone, the IRS is not going to claw back. They're not going to come back and try to get the the taxes for the 13 million that was originally gifted when it gets lowered to 5 million. So that's one of the strategies as well, is to use so gift tax and estate tax, it works unified. So basically in our lifetime right now, we have 13 million to give, either through inheritance when we pass away, or through gifts during our lifetime. So I can give, Jack 13 million right now, and both of us don't have to pay anything. There's no gift tax.
I would like that.
And so, but if I use it now, that means I don't have it anymore when I die. So if I still, have 10 million, then that is all taxable because I've used my lifetime exemption during my lifetime as a gift. So it's a give and take, and a lot of times we get CPAs involved, financial advisors involved, to just help the client calculate out what's the best case scenario for them to try to minimize or reduce as much as we can. So this is the tax part of the estate planning. So I mean, these are just examples of type of assets. So if you gift real property interest in US, it's all it's subject to gift tax. As long as you're not over that threshold, you're okay, the 13.6 million. But so real property is tangible. Stocks, if it's like one of those things that you're buying, like shares of, let's say, I don't know, like if you're at Fidelity and you're buying stocks and shares, trading, those are considered non-tangible, intangible, because it's something you can't really touch or hold. So then those are not subject to estate tax if you're a foreigner. So the 60,000 only applies to the tangible things, cash, property. So those are the more obvious things that are tangible property. But if you own shares of, like, if you're trading, those are not tangible. So those are not subject to that $60,000 calculation. So many times we tell our clients, maybe change the way you're holding your asset, maybe make it into intangible somehow if you're able to during your lifetime, if you're not planning to become a US citizen or green card holder by the time of your passing. So just certain things to, think about and try to plan ahead for. So this is like a typical scenario for most families. If you husband and wife, you have 2 kids, we set up your family living trust. Usually, we use your last name. Let's say for Jack would be like Ma Family Living Trust, right? And then what we would put into the trust would be your home, your bank accounts, your stocks. If you own a business, sometimes you also have LLC that holds rental property, and we'll put the LLC into the trust. So this is a pretty typical and common structure that we see for a lot of families. And then with estate planning, besides the trust is kind of the main, kind of the center, the key document, but it also requires other kind of documents to supplement it, right? So we call these ancillary documents. We also include a will. So this type of will is called a pour over will. So kind of like the way the name states, in case you leave something out, let's say you opened a CD and you forgot, to plan for any beneficiaries for that CD or that savings account, that checking account, then the pour over will captures it, right? And then it'll say, oh, like Jennifer Fu, her wish or intention, she created a living trust. Her wish or intention is to have everything flow through her living trust. So these things that you left out, you forgot about, will get poured back into the trust. But keep in mind, this is for the small things. Sorry, I went too far. So this is for the small things. The 184,500. Remember that dollar amount, right? So if whatever you left out total does not exceed the 184 5,000, then this pour over will be sufficient to avoid probate and be able to pour whatever you left out of your living trust into the living trust without needing probate. So it's a catch-all just in case, and we call those residuary items that you may have left out that are smaller, not as significant, but it also still helps to have that in case you left out certain bank accounts and whatnot. But the key is that it has to be under 184 500. Otherwise, if let's say you forgot to title the house, right? And it's still under your individual name and you pass, but then you have 2 other homes, investment properties, whatnot, that you did put into your trust. But it's just this home that was left out because it was purchased recently. Then what happens is you have to go through probate because this home is over 184,500 that you left out, even with the pour over will, even with your trust. This home still has to go through probate. But the good part of it is going to be a shortened probate. It's called Hegstadt petition, because what we do is we show the court everything was in his trust, but he just forgot about this house. And that intention, based on the will, based on the trust, everything was written out to include everything. And then so the court will look at this Hegstadt petition. Usually that's like less than a year, maybe 3 months, 4 months, until we can get that back into the trust. So then once the court decides that, then we're able to record the deed into the trust again to avoid the full probate, where it takes 1 to 2 years and it gets complicated with creditors. So it does still help with the trust, even if you don't fund everything in, because it shortens the entire probate process. But this is all to say try to make sure everything is funded. So we generally recommend to our clients, make sure to just look at your asset list, make sure maybe every year, every other year, just to make sure everything's up to date, and that everything is funded in your trust. We also include the power of attorney and healthcare directive. So those are in case generally, we don't know how things will happen to us. So in case there's a period of time we are sick, incapacitated, generally with 2 doctors saying, Jennifer can no longer manage her own affairs, or I'm in a coma. I haven't passed away, but I can no longer take care of myself. Then you ahead of time authorize through a power of attorney everything that this person can do for you financially. So they can, help pay your bills, sign off on your checks, file taxes on your behalf, apply for government assistance, all of that through this durable power of attorney. And then the healthcare directive is the healthcare power of attorney, right? So in case, I'm in a coma and I can't make any decisions on my own behalf, then I designate and authorize who can do so for me. And this is also one of those things where people mistakenly think that, oh, I'm the spouse, I can make that decision automatically, but that's not the case, especially if there's conflicting decision making, right? So there was a pretty popular story about a daughter, a wife who fell into a coma. The husband wanted to pull the plug, but the mom wanted to keep because she thinks her daughter has a chance. So then, but there's no advanced healthcare directive, so they ended up going to court against each other just to let the court decide who has the right power to make that decision on behalf of this woman who's in a coma. So we don't want any of these things to become an issue. So pre-plan, pre-authorize, in case that time comes where somebody has to make that choice for you. And in this healthcare directive, you can make your own choices ahead of time. So if you already know, do I want to donate organs if I pass? Do I want to prolong my life with artificial means? Yes or no? Do I want to have pain medication if it hastens my life? my passing. So all of these things you can ahead of time in this healthcare directive make that decision if you already know kind of how you want your treatment to go. Otherwise, you could just authorize whoever it is that you trust, that you think would act in your best interest, to make those decisions if that time comes. So the estate plan includes all of this planning. Okay, so the good thing about having this revocable living trust is you still have full control. So that's also a myth that I always hear from clients. They think like, oh, if I put my stuff into a trust, then can I not sell it anymore? Do I lose control? Do my kids already receive it? No. It's still yours. It's still under your social security number. You can still add or sell your trust assets. You can put limitations and conditions into how things are distributed, especially if you have minor children. So we have clients, if they have a home, they have 2 kids, and they're all under 18. Then they think, oh, if something happens to me, number one, I can name a guardian to take care of my kids, but financially, I don't necessarily want them to receive everything the minute they turn 18, right? It's too young. They're not mature enough. They still, need some guidance with finances. Then you can stagger the distribution. You can say, at 21, they get, 30%, at 25, at 30. So you can make those conditions and make the distributions, just like installment payments instead of like a lump sum. And this will allow your kids to also protect them in case they're in a accident, somebody sues them. They're just beneficiaries. These assets don't belong to them yet. So creditors can't go after them for whatever they don't necessarily own, right? So that also helps protect some of their assets prior to inheriting anything. Okay, so this is an example of kind of the difference with the tax status for husband and wife. So this one, in this scenario, Mrs. Wang, she's a permanent resident. So her lifetime estate tax exemption is 13.6 million, right? We're in 2024. Mr. Wang is a non-resident, and his lifetime estate tax exemption is only 60,000, right? So if they pass away, this is the number that they're looking at that's exempt from estate tax. And then they have a living trust, a home in it, LLC that owns a rental property, and maybe a business building. Then, so husband and wife, we have a couple of trusts that we generally utilize. So the first one is called a disclaimer trust. So the disclaimer trust, what happens is when the first person passes away, the surviving spouse still has 100% control over the entire trust. So all the assets still remain in this trust unless the surviving spouse disclaims a portion and allocates to a subtrust to claim or defer the deceased spouse's estate tax exemption. Once the surviving spouse dies, then everything passes to their named beneficiaries. But the key to this is that the surviving spouse can still make changes to the entire trust, right? So if he or she, let's say, for instance, wife dies and then husband survives. So he still has full access and control to the entire trust. So he can still change the beneficiaries. He can still sell the properties in the trust. He still has full access. And, many times this is okay for a lot of families. They're fine with that. But then we've come across situations where, and this was a pretty recent, pretty well talked about story of a couple that was in the Bay Area up north. And then wife died, suffering from cancer for many years. And then the minute or the day, I don't know about the minute, but when she died, husband kicked out the mother-in-law, father-in-law from the house, immediately remarried the next day, changed out the entire trust. So so that was a terrible scenario where they had a disclaimer trust and surviving spouse had 100% control. So he whatever he did was legal because he still has the right to do that. So if you're concerned about that ever happening, or sometimes it's, this may not be your first marriage and maybe you have kids from a separate relationship and you want to make sure your assets are protected for that specific side of your family, then we talk about this AB trust. So when that story hit the news, I think it was in the Chinese news a lot, my clients asked me like, oh no, this can actually happen and I want to change my trust now. Then we talk about this AB trust scenario. So this type of scenario is when one person dies, there's a mandatory split. So community property, California, husband and wife each own 50% of your community assets. So then if this happens, this type of trust, there's a mandatory split where the surviving spouse can only control and change his or her half. But the person who passed away, the deceased side, it becomes irrevocable. So husband or wife cannot change the other 50%. So that 50%, at least is still designated to those beneficiaries that you plan for ahead of time, and that's not going to change. And that cannot be changed legally unless all the beneficiaries sign off on it and agree and consent to it. Otherwise, the surviving spouse cannot change that half of the deceased person's side. And then, so people ask me, well, what if the spouse wants to sell the house, right? The surviving spouse. He or she still can sell the house, but the proceeds have to go into an irrevocable trust bank account now, half of it. And then the other half, the surviving spouse can access and spend and use as he wishes or he or she wishes. But the other half cannot be changed. So this, at least, you can protect half in case something does happen, but keep in mind, this is mutual. So I've had clients where they say, oh, wife says, oh, I want this, but if he passes away first, no, I still want 100% control. But no, you can't do that. It's a mutual thing, right? So if husband dies first, this happens. If wife dies first, this also happens. So it has to be where both of you mutually agree to have this mandatory split, regardless of who dies first. Okay. So the trust that we've been talking about is revocable, right? So during your lifetime, if you and your husband or if you alone create a trust, you can change it during your lifetime, or you can revoke the whole thing during your lifetime. You change your mind, you want to cancel everything. It's all within your control. And this is, again, like our objective says, is to, plan ahead, avoid probate, all of that. But because it's revocable, if somebody sues you, everything is still under your social security number. You still have all access to your assets. So it's not protected from lawsuits, not protected from creditors. If you get sued, if you owe money, there's a debt collector at your door. All of this is subject, in your family trust, is subject still to the risks of having those taken away. One way of not having, or having asset protected is through an irrevocable trust. So irrevocable trust, once you establish it, and you put whatever asset into this irrevocable trust, you lose the control. It's no longer yours. The irrevocable trust has its own tax ID. So when people search, Jennifer Fu's, somehow they know, everything that I own. Whatever I put in my irrevocable trust is no longer going to be listed in my list of assets under my name anymore because I've given it away. So it's kind of like same when you give something to another person. So if I give a house to Jack, that house is no longer my name anymore. So if I get sued, that house is not going to be at risk because that house now belongs to Jack, right? So same thing with an irrevocable trust, except it's not a person, you just set up this structure. It's kind of, you know, a lot of times I compare it to like a business or a company, or you know, or like a safe deposit box, you lock it away and it's no longer accessible to you. And somebody else has the key. So you have to appoint like a third party trustee. They manage it for you. You can name your children, your family members as the ultimate beneficiaries. And so whatever asset you gave away, put into this trust will eventually come back to your family. But basically during your lifetime, you're not really planning on utilizing it anymore because you want to protect it. You want to lock it away. Types of irrevocable trusts also differ. So a very popular one is a life insurance irrevocable trust. So a lot of times, you know, we buy life insurance and then it's just there, right? But we don't think about the proceeds counting towards our estate. So if you buy a $5 million policy, that $5 million is added to your house, your business, whatever you own during your lifetime, into that total of that 13.6 million. So people say, well, but I don't own it. That doesn't get paid out until I die, but still that belongs to you if you purchase the life insurance policy under your name. So if I buy my life insurance policy under Jennifer Fu, I own the policy, it's on my life. That policy belongs to me and is counted towards the total estate. So sometimes we want to remove that, right? So if you're close to the estate tax lifetime exemption dollar amount, you don't want to have your life insurance added to that, right? You want to lower your total estate. So then we can establish an irrevocable trust to own your life insurance policy. Okay, so the policy belongs to the irrevocable trust. It's not under your social security number. It's a different tax ID. So when you pass, whatever is the proceeds that get paid out from the irrevocable trust is not taxable. It's not based on your estate tax. So this is a strategy that sometimes people use to also have to pay if they have to pay estate taxes, their children. So instead of them needing to sell like a house to have liquid funds to pay estate taxes, you leave them with a cash, right? Basically, they have a lump sum cash at your passing in case there is a need to pay for estate taxes. And then charitable tax or charitable trusts are also a popular type of irrevocable trust if you want to try to donate some to charity and then also get maximum tax deductions. Dynasty trust is also popular because a lot of times you want to prolong your assets to go to multi-generation. California does have a slight restriction with dynasty trust. So trusts have to end in California. They can't just keep going on. So California has a state law where the maximum time frame basically is 90 years. So if you want to go beyond that, a lot of times people look at other states for dynasty trusts, or we just advise them if the time frame ends, then in the trust, we designate that whatever generation it is at that time, they have to create another dynasty trust in order for those remaining funds to move forward. So then you kind of restart that time. But these get very complicated. It's too much to kind of talk about within an hour's time. So, you know, if there's any interest in that, we can talk a little bit in more detail based on your situation. Okay, so certain things are exempt by creditors, right? So creditors, if you do have creditors, a lot of times they cannot get into your retirement plans because those are restricted plans, right? Sometimes, you know, you can't even access them without penalty. So same thing, creditors would not be able to access those. And that's with the exception of spousal or child support liabilities. So if you are ordered by the court to pay for child support, then even your retirement plan funds are accessible. Life insurance. So if your policy doesn't have any savings, it's or it's an insurance policy with savings, but the funds have to be paid to your basic living expenses, then they're also exempt by creditors. So these are just examples of things that you can utilize to make sure most of your assets are then protected from any creditors. And then your trust assets. So if you're, let's say, assets and interests are exempt if the debtor is a trustee holding funds or assets in a trust. So this is a little confusing. So if it's a revocable trust, like I said, you're still subject to liability of creditors, right? Because you still have control. Everything's still under your social security number. But if it's an irrevocable trust, sometimes, you know, we have family members. I have clients where they have family members overseas that want to bring money into the US and gift it. But then they also don't want to be exposed to risks of getting things. They don't want to directly gift it to the US person, because then the US person has a lump sum that might be subject to liability in case they're high liability if they run a business, whatnot. Then they create a irrevocable trust, put the funds in the irrevocable trust, and then have this US person act as a trustee. So the trustee of this irrevocable trust, if they get sued, this irrevocable trust assets are not subject to creditors, because the trustee is only managing, right? The irrevocable trust owns the assets. The trustee only manages. It's kind of like you hire a manager for your business. If the manager gets sued, your business is still fine because it's the manager that is subject to that liability. So it's only whatever the manager owns. If he goes and gets into a car accident and he gets sued, your business is fine because he's just a hired person, right? So similarly with an irrevocable trust, if you're a trustee, you're managing these funds, but you don't own them. So those funds are protected. LLC. So, you know, I think many of us, if we have tenants that sue the LLC, then your other personal assets are supposed to be shielded, right? Because that's why there's a limited liability company that holds your interest. But keep in mind, this is inside risk, right? So outside risk, you're still liable. So if somebody gets hurt on the property, if your tenant has issues and wants to sue the landlord, they sue the LLC. So then whatever at risk is that LLC, the home that you own in the LLC, and any other assets you own in that LLC. But if you're out driving and you get into a car accident, your insurance is not enough to cover, and they sue you personally, then this LLC is still open to risk, right? Because you're the owner of the LLC, and you as the owner got sued. So LLCs only protect the inside risk, not the outside risk. All right, so what can I do next? So I think it's important to just, again, plan ahead, right? So what I usually tell clients is, you know, you should have a general idea of what your value, your worth, your net worth, and then itemize that out. And then you'll know based on that what necessarily you may need to do to be under either the 13.61 million threshold, or maybe the 5 million threshold, as we are supposed to know, at least currently until 2025, it's going to go back to 5 million. So if you're close to that 5 million number and you have insurance, you have, you know, a number of things, then we can kind of circle things out as to how you want to plan to minimize your estate taxes. And then also who you trust, right? So trustee is very important, successor trustee. So if something happens to you, who do you believe will act in your best interest, in your family's best interest? One thing I forgot to mention is if you have adult children, they can be beneficiaries and trustees. So if you believe, hey, mature, they're responsible, I'm going to leave everything to them anyways. They can also act as the trustees, your successor trustees, meaning that if something happens to you, then they'll take over and make sure that whatever assets you leave behind gets distributed and transferred to themselves. So it's just, them acting on their own behalf. So that works as well. But if you have restrictions, of like how things are going to be distributed, then generally you want your trustee to be somebody else besides your beneficiaries, right? So there's a balancing and a check to oversee who's going to be able to follow those instructions. So I think it's important to just start thinking about who around you you can name as a trustee. And then I know we've had situations where people, they really don't have anybody close to them, no family members, no close friend that they believe would be a good trustee. Then they can look into corporate trustees. So banks, trust companies, there's professional trustee services. So that's also an option as well. And then, if you want to consult with my office, we're happy to help. We offer 20-minute free consultation. Usually if that goes over pretty much, like we can talk for like half an hour, no fees for that. Just to see, what type of options you have and what we may recommend based on your situation. So but that's all I have for today. I hope that was very helpful. And if there's any questions, I'm happy to answer them.
Thank you very much, Jennifer. That was super helpful. I learned something new, and then some nasty stories about that without a living trust. So basically, giving just everyone a kind of overview, not overview, recap, just a reason to get a living trust, and then which it's going to also include estate planning is basically, you minimize the cost of probate, and of course the time that you had to go through probate, and you basically, as part of the estate planning, there's there's a directive, healthcare, or so basically taking decision pressure off the heirs too financially, because their assets died in probate, or they have to make these healthcare directive. And as far as I understand, if you go through probate, all your asset also becomes public information, right?
Right.
Yeah, so that could be another reason to want to get these estate planning and trust set up. And there's also the avoiding potential family dispute if it wasn't set up properly. And of course, with the estate planning, there's way to avoid taxes, estate tax, especially if that limit gets sunset. Now, $5 million becomes a lot more easy to achieve, with the life insurance policy. Did I miss anything? That's kind of general good recap of
No.
why it's important.
Yeah, I think that's about it. A good recap.
Okay. Yeah, let me go through a couple of questions. So Jeff here asked a couple questions. So I guess this kind of mentioned, but what happened if all listed trustee died before additional trustee can be added?
So within the trust, it'll allow the beneficiaries to appoint a successor trustee if there's a vacancy. Um, so that's generally kind of the way to go about it. But if the beneficiaries are still minors, then whoever wants to act as trustee will have to go through the court to get appointed. So it's better to name some additional trustees. So usually we ask most of our clients for at least two, and then maybe last, just like just in case, maybe put like a corporate trustee to capture and be the last in line. But if all of them have passed, then one is the adult beneficiaries can vote to appoint a successor trustee, or you'll have to go through court to get a trustee appointed.
I guess this goes with the essence of having a living trust, just in case. So
Right.
be prepared for that. Did that answer the question, Jeff?
Yeah, I think actually the answer would be probably do trustee, a backup trustee, and then
Yeah.
corporate trustee. Sounds like the safest way to go. So yeah, thank you.
Yeah, and then you also ask about joint accounts. Does that work around inheritance tax? Can you do you mind
So
clarify that a little bit?
if I have a joint account where both of, you know, if me and my child both have the names under that account and both have 100% access, I guess, to it. I don't know if that's so. And if I die, then and if this joint account has, let's say, $200,000 in it, the joint account doesn't. I mean, you know, I just basically fall off the account. I would guess, but I don't know if that makes sense. Does that make sense for like if I just make a joint account, wouldn't that just allow my son to still be able to have access to all $200,000 without probate?
Right, so if it's a joint account, then yes, the survivor of that account would still have 100% access and not have to go through probate. It's just sometimes, you know, clients aren't aware of logistics. So if they inform the bank, oh, this person passed away, I want to close out the account, then they immediately freeze it. So you don't want to put the bank, like once the bank is on notice, they'll freeze the account or require some paperwork before anything can be done. But like you said, the workaround, quote unquote, would be whoever the surviving person is on the joint account can transfer the money out before anything is frozen, and then that I technically would, I guess, be the workaround. And same thing for husband and wife type of accounts. If the
Right,
husband
right.
comes first,
Yeah,
then you know,
I get it.
wife
Okay.
still has 100% access. Correct.
So of course that only applies to cash. Obviously, anybody with the house, like you said, would pretty much in California automatically go over the 180 some $1,000. I was just wondering, you know, what happens to that. But you mentioned in joint account they could still freeze it if one of the holders passed
Mhm.
away.
Yes.
Interesting. Okay. All right. So that's something to still. I mean, that's just annoying. Then basically, we still probably would want to
Yeah.
avoid that. All right. I didn't know that. So thank
Mhm.
you.
And then you also have a question about trustee transfer asset equals just going to RRCC.
Oh yeah, because that was one of the steps. I think in one of the slides, like the last step is to transfer. Um, like I think one of the very early slides,
Uh-huh.
there's a step called trustee transfer asset. And then, so my question is, does that step just mean going to the registrar, recorder, county clerk?
Oh, so yeah, so when we transfer the asset into the trust, or out of the trust when somebody dies, is that what you're
No,
asking?
no, I think you're very like probably the second or third slide on the last step. It's like you set up the trust, I don't know,
Oh,
like,
okay.
and then the
Yeah.
last step is to transfer your
Uh-huh.
own assets into the trust, I guess. And then
Right.
I don't think I didn't hear the elaboration on what actually has to happen to do that. Is that just going to the registrar recorder to
Right.
record it?
So we would prepare for real property, we would prepare a deed. So basically from you individually, it'll get recorded into your trust. So it'll be like Jeff to Jeff's
Like,
trust.
would I quick claim it to my trust? Is that what happens?
Yeah, so now it's going to be titled in the name of your trust on your
Okay,
deed.
I see.
Yeah, and then that gets recorded with the county recorder's office, correct?
Okay, all right.
Mhm.
Thank you. Those are my
Mhm.
questions.
Okay. Yeah, and I have a question from Casey. She say I have a transfer on death deed on my house, and designated beneficiary is my brokerage account. These are excluded from the probate process, and don't necessarily need to be in the living trust, right?
Right. So the assets that you have named beneficiaries, they don't need to go living trust as long as your beneficiaries are still alive. So the risk of doing that is number one, if your beneficiaries are minors, I would not recommend naming them directly as beneficiaries, because if something happens to you and they're still minors, again, they have to go through guardianship to even touch or
Mhm.
inherit that, because they can't legally inherit it yet. And then also another risk is if whoever you designated as a beneficiary passes with you, or because you can't name like a backup beneficiary on a transfer on death deed. So that's kind of the situation that we see. Sometimes we come across where they eventually still have to go through probate because whoever they designated is no longer alive or no longer around. So that creates that type of risk. But technically, yes, if you have a transfer on death deed where your designated beneficiaries are alive and they can inherit, then that house does not need to go through probate. And any of your accounts, if you designated beneficiaries, as long as they're over 18 and still alive, then yes, they can inherit based on your death certificate and your designation of them as beneficiaries.
So a lot of the risk is based on whether or not your beneficiary is actually a minor, right? While you're and if you can't when you can't name two beneficiaries, I guess.
Right.
In the living trust, you can then
Mhm.
like you can set up conditions, right? If the first beneficiary also passes away with you, who's the secondary, or I guess even a backup to the backup beneficiary. Okay.
Right. So there's more backup, like a backup plan A, plan
Yeah.
B, plan C for
Okay.
that situation. Yeah.
Great.
Mm-hmm.
Okay, got one. So KCC, thank you. So I think the question was answered. Tammy, I know it's. I also want to be respectful of your time. It's 11. Do you have a couple minutes? We have probably a couple more questions.
Yeah, that's fine.
Okay, yeah. So Tammy Shen, Tammy asked, what is the approximate typical cost generally for starting a basic trust living will, a living trust, and how do you update a trust like 10, 20 years later? Like, or I guess how frequently do you update it?
So so the cost depends on the number of assets you're going to fund into the trust, and then also if you're individual or husband and wife. So individual, we start off at 2,700. Husband and wife, we start off at 3,200. But you know, the specifics will depend on kind of your situation and how many assets you have. And then in terms of updating the trust, we can do a trust amendment. If you're just only, you know, changing certain details of the overall trust. If you, I mean, we recommend reviewing it every couple of years, just number one, to make sure all your assets are in there. You didn't leave anything out. And then also if your situation changes, right? So if you have like a new family member, people get married, there's more children, grandkids and whatnot, then, you know, you want to revisit that and maybe make some changes. So the timing really depends. I mean, I think every couple years, I would say at least review it. And then if your family dynamics change, then certainly review it and decide whether or not you need to make some updates to it.
And updates would also be through the office or something that we would be able to. Okay.
Yeah, so we can do the trust amendment for you. It basically just requires us updating some language or changing out some people or trustees and things like that. And then if you need us to update kind of your list of assets, we can do that too. That usually we don't charge for that. And that would literally just be like an itemization of all the assets that you listed to us. So sometimes, you know, you buy a new home, then we'll help you write the address on the back of your trust. And it's a reference sheet for all the successor trustees to know where everything is. But you know, when you do purchase a new home, let's say you already have the trust done, and then you decide you want to buy another property. If it's going to be in your individual name, not like an LLC, then I would recommend using the trust to purchase it. So you just directly, when you open escrow, tell your escrow officer, instead of titling it in my individual name, I have a trust. Can you title it into the name of the trust? And we'll provide to you what we call a certificate of trust. That details the name of the trust, who the trustee is, who the current, you know, authorized individual is, and then it's a notarized document that the escrow officer can rely on to prepare the deed and make sure that it's directly titled into the trust. So then, you know, at the county, it's already in your trust on the title. So all we need to do on our end is just update that list in the back of your trust so that your successor trustee can reference it.
Thank you.
I don't see any question. Anyone else has any additional question? I guess that's it. Well, just want to say, you know, thank you very much, Jennifer, for taking your time on the weekend to do this for me and my clients. And thank you everyone to join me on a Saturday morning. If there's additional question, I also, you know, for Jennifer, I mean, based on the presentation, you know, this living trust estate planning is super, it's it's very specific to your need and very customizable. So if you have additional question or more personal ones, definitely you can reach out. I just type in her contact information again in the chat. So that will be her contact information. You can reach out, and if you guys have question on real estate, just reach out to me. Well, thank you very much for joining me today, and thank you very much, Jennifer.
You're welcome. Thank you, everybody. Have a good
Bye-bye.
Saturday. Bye.
Bye.